Hello and welcome to Restoring Our American Republic. I'm Chuck Benoit with The Nature of Things, where we are realigning God, government, and natural law so that we might restore our American Republic. For a very long time, probably even before Ronald Reagan, the Republican Party has shown itself to be, well, less than Republican minded. They hated Reagan as much as they hated President Trump. Uh, but by what standards do I make these claims? Well, President Trump governs like a Republican. By what standards? He governs for the people. Congressional Republicans are not working to codify his efforts. And these are not some personally subjective ideologies only, but the Republican Liberty Caucus has standards as well. And using those standards, the Florida Republicans in Congress are an abject failure when it comes to Republican ideologies. The average score for Florida Republicans in Congress voting on Republican-minded bills in Congress is 62, not even a passing grade. So what I have here that I'm going to put up on the screen for you is um, the score out of a possible 100 for Florida Republican congresspersons. And I'll just hit a couple of them. Right at the top, I have Jimmy Pertonis. He's a name that is recognizable to me. He got a 36 out of 100. And then I've highlighted in bold those who actually got over 50%. We have Kat Kamek at 52, Aaron Bean at 55. Then we come down here to Randy Fine over here in Florida 6, right up north of me. 36 out of 100 score. Corey Mills, 58. Good news, he's over 50. But Daniel Webster, my congressman, a mere 42 points out of 100 possible. In my estimation, this is just not acceptable. Let's just finish this up with Anapolina Luna, who actually has a passing grade of 67, and George Stube at 77. Finally, Byron Donalds, who's running for Florida governor. Uh, Good news, at least he's over 50, but only at 58%. In my estimation, these simply are not acceptable. Uh, and those of us who are trying to bring this up at the state level, well, we're harassed and some of us even thrown out of the party. Now, I know I'm speaking to people in the know. That's why we need to be liking and sharing this type of information so others will know. Again, this isn't about necessarily informing you. We want to inform your friends. So please like and share our program. Please, please. And thank you. And with that, let's welcome Mike Levine. Good morning, Mr. Levine.
Morning, Chuck. What an interesting subject you open with today. Here's what I want you to do. Go through the list, Chuck, one at a time, rapid fire, ask the question, does the Republican Party of Florida support this legislator? And you're going to find out that the Republican Party of Florida enthusiastically supports them all. And probably the one they like the least is Anapolina Luna, who has the highest score. So, and then, of course, as we bemoan and rail against these Republicans who do not govern according to the Republican Liberty Caucus of Florida's values, the Republican Liberty Caucus of Florida itself supports the Republican Party of Florida, and really, you don't see their leadership showing up for the press conferences outside of RPOF quarterly meetings, and you don't see their leadership showing up for the press conference that would push back against the stripping of the actual shutdown of the Manatee County Association, not association, but Republican Executive Committee, because they had their Trump Day dinner last week, and Laura Trump was speaking there. So it's really interesting. And of course, you can't leave out the fact that any of these people are welcome keynote speakers at Republican Liberty Caucus of Florida events. So while I agree with everything you're saying, Chuck, these guys don't uh, legislate according to Republican values. The Republican Liberty Caucus of Florida celebrates them when it's convenient for them and throws them under the bus in order to create a image in the state of Florida that they are true libertarians, which they are not, Chuck.
Yeah, well, it is very, very sad that those of us on the right still have divided preferences or allegiances might be a better word. And as long as one of your efforts is to maintain good standing with your legislators, you, I guess, find yourself sucking up to them. So,
End of the day,
uh,
Chuck, again, what do they say? A man who will stand for nothing falls for everything. Isn't that? I'm sure there's a million little mantras that we could apply here, but I'm just saying that I find this to be hypocritical, and I'll leave it at that.
there you go. There you go. Well, this morning we decided we were going to be talking about HB 1465, put out there by Representatives Alex Andrade and Fabian Basabe. And it's restrictions on local governments after a hurricane. So I guess what we're dealing with is well, what happens after a hurricane comes through, causes some major damage, and how do we fix it? Um, we thought we'd start with a few lobbyists and find out, well, who's really lobbying this legislation. And the principal lobbyists, first of all, Osceola County, uh, the Associated
Okay, so they're
Industries of,
probably against, right, Chuck? Well, once we get into this legislation, we're going to find out that the local governments have good reason to be to oppose this, and some of the other principals who are signing up to lobby this bill, one way or the other, have reasons to support it, and we'll get through it as we go through the details of the bill. Chuck, go ahead.
sure. So you feeling Osceola County would be against it? What about Associated Industries of Florida? Or
Yeah, we know they're going to be in support of the bill. Mhm.
Surf Riders Foundation,
I don't know who they are.
okay. Florida League of Cities,
They should oppose it. This exposes them to litigation.
City of Bartow, same thing, I guess.
Same thing. All of the local governments and organizations that represent local governments should be opposed to this bill.
And then the others are Pinellas County, Florida Association of Counties, and City of Wauchula. So you feel like pretty much all these lobbyists, other than maybe a couple of them, should be lobbying against this bill.
I'm sure they are lobbying against the bill. Even our local county commissioner spoke to me. The reason that we're doing this today is because one of our local county commissioners was very concerned about it. So I pulled it and took a look at it. And with respect to the commissioner, thought that we would just kind of dive into this and see what this is all about. And we'll get into it. We'll talk about it in more detail as we break it apart, Chuck.
There we go. I think another thing we decided to do was pick up on a couple of definitions that are very, very important to the legislation. So I'm going to do my best to move through this without sounding confusing because well, these definitions, in my estimation, are a bit confusing. But please jump in as soon as you want to say something. I'll try to break it up in a reasonable fashion. So the first one is burdensome. We're going to define burdensome. It's as an action proposed, enacted, or enforced by a county or municipality that decreases the allowable density, intensity, or floor area ratio on land that decreases the amount of property available to be developed.
Okay, so let's take a look at that. So this is the root of the problem because the state doesn't like the way that cities and counties are handling growth management, Chuck. So the state is coming out and saying that after a hurricane, um, cities and counties are prohibited from decreasing um, density and intensity of land use. Okay. So the property owner is going to be for that. They're going to say, yeah, I want to get the highest density I can for my property because property value is determined by density and intensity of land use. And the state of Florida wants it. And I've spoken with many legislators, and I'm sure you have too, that are just absolutely outraged about the decisions that local governments are making as it relates to land use density and intensity, Chuck. So
Okay,
burdensome
again,
means that you're reducing their that you're reducing density and intensity, which lowers the value of their property and restricts their desired use of their property in many cases, Chuck.
okay, again, we're defining the word burdensome as it relates to this legislation. It has the effect of increasing an impact fee exceeding 25% over a 2-year period, or that restricts or limits the use or future use of real property such that negatively impacts the economic value of the property.
So there's a lot of ways to skin a cat, right? You can you can achieve your objective through regulatory enforcement and interpretation, or you can just make it very expensive for people to do what they want to do. And that's this portion of the definition goes to the second part, which says, a county might or a city might say, you know what, we know that we can't restrict your desired use of the property through regulatory actions. So what we're going to do is we're going to just raise your impact fees and we're going to bill you high costs for filing various different reports that are required in order to get the land use that you want. So we're against you doing what you want, Mr. Landowner, Mr. Developer. So we're going to make it, we're going to use every tool in our toolbox to prevent you from doing that. And here's the Florida legislature basically specifically restricting the cities and counties from raising impact fees and filing fees in order for property owners and developers to do the things that they want to do, Chuck.
So what we're dealing with is the state of Florida determining what would be burdensome for um, those who want to rebuild at a higher impact fee, higher
Not
density,
higher, at the same impact fee or higher.
same or higher.
Okay, because this is the next step, right? A lot of cities and counties find that after a storm, this is a great way for them to reestablish those densities and intensities. And sometimes they want to lower densities and intensities. And that's what this is about. This isn't about raising densities and intensity. This is the state of Florida saying to the cities and counties, you can't reduce density and intensity, and you can't do anything that would diminish the value of a property owner or developer's property. That's what they're saying. Okay.
Okay, so
So if I'm a property owner, I would agree with this. I would be lobbying for this. Associated Industries of Florida is going to say that our members are developers and property owners, and we want them to be able to develop at the highest density possible. We appreciate the state of Florida coming in and restricting the cities and counties from reducing the densities of our clients' properties. Okay, and that's what this is protecting the landowner and the developer from. It's not that it's raising intensities and densities, but some cities and counties, Chuck, will use that opportunity to reduce density and intensity. So this is the argument that's happening in this legislation, Chuck.
no, no, they would do that. Why? Because of the damage done with all the storm water, et cetera, and they're feeling that there's just too much growth or too much concrete on the ground kind of thing.
A lot of different reasons. They may see that based on amendments to the land use and plan and comprehensive plan that basically the way that now that we have approved or developed and built projects, then now that that project exists, when this land use was put in place, that project didn't exist, and now that project does exist. So now we have a different view of how this property should be used. So there's a lot of legitimate back and forth on both sides of this argument, Chuck, as you know, as to what that is. But the state of Florida, long story short, they want the highest possible densities and intensities they can get, and of course, they are, um, developers and big landowners support the legislators in Tallahassee financially. So the legislators are supporting their donors and at the same time holding local government accountable for the local government at times attempting to reduce um, land use densities and intensities, Chuck. And the difference would be between basically residential and commercial, the way
So,
that
so
density is
we,
calculated in residential versus commercial. Mhm.
so we move from what's burdensome to what's restrictive. So defining restrictive regarding HB 1465, it's an action proposed, adopted, or enforced, including the interpretation of existing regulations by a county or municipality concerning the review, approval, or issuance of a site plan development permit or development order. I can continue going on to the extent that
No, that's
those
fine. That's a
terms
good
are
place to
defined
stop,
by
right?
Florida Statute 163.3164 or concerning policies or procedures relating to its comprehensive plan or land development regulations. And I can keep reading here that increases the time for such review, approval, or issuance, or that creates additional reviews of applications and includes the inaction by a county or municipality that creates a delay in such review, approval, or issuance. Now that's quite the definition.
Okay, so long story short, Chuck, this is just about roadblocks and obstructions. This is what it is. So basically, you're standing in front of a regulatory body, either a city council or a county commission, and you say, well, Mr. City Councilman or Mr. County Commissioner, this is the reason that my project is, I'm just going to go through your requirements and I'm going to tell you why my project checks all of your boxes. And then the developer, the land use attorney, or whatever, whoever's making the pitch, they start going through, and then the commissioners start going point by point, and they're saying, "No, no, I understand why you think that's true. I understand why you think that your project checks this box, but I interpret this regulation differently. So, no, in fact, in my opinion, your project does not check that box." So that's one way that, again, this happens in courtrooms all over the country every single day. Okay, this is the interpretation of the law, right? So the county commissioners and city councilmen say, yes, I understand your interpretation of that regulation, but that is not our interpretation of it. Our interpretation of it is this. And then you get into, okay, well, let's assume that the developer does check all the boxes according to the comprehensive plan and the land use ordinances and everything. Then they're going to say, okay, well, we couldn't defeat them on that basis. So what we're going to do now is we're going to stall and delay. Okay, well, you need to have a hearing. Well, we're not putting that on the county commission's agenda. And we can't really tell you exactly when we're going to take it up, but we understand that you want it. And we're just going to delay, stall, stall, stall. And that's another tactic of defeating, right? Justice delayed is justice denied, right? So that's the other part of it. So you're seeing here the state of Florida, who understands this because they're in the business of regulating development, and they know what tools the cities and councils have in their toolbox to deny, make things, cost, drive the cost of development out of feasibility, and then just the whole process of getting through the system. This is the red tape that we all complain about. And that's what that is, Chuck, as it relates to the definition of restrictive.
Okay, you then reference chapter 252, section 422, subsection 3, paragraph D. And you say that this section adds circumstances under which a comprehensive plan or land use plan can be enforced. This paragraph allows enforcement if the enforcement is necessary in order to remain in compliance with Florida Statute 163.3191, or if enforcement is necessary in order to be compliant with federal or state law.
So there you go. There's the state of Florida saying that, if you're just talking to a landowner or a developer, then you cannot adjust your comprehensive plan. But if you have to adjust your plan to stay in compliance with state law or things that the state is interested in, then you can. So it's, depending on the circumstances, some cases you can, some cases you can't. And of course, the state doesn't want anybody violating their rules, which are delineated in statute. So they reference those statutes and say, if you must adjust your comprehensive plan to comply with the statute, then you can, because we are very interested in you following our laws. But if a developer comes to you and says that he needs you to support the existing land use or comprehensive plan, then you cannot change your comprehensive plan or yet land use based on the application for a site plan approval or building permit in order to accommodate the developer. Okay, so that's the state of Florida playing both sides, right?
Okay, so the next
Understood?
paragraph says this section adds circumstances allow changes to or enforcement of municipal or county comprehensive land or land use development plans if the enforcement or change substantially increases the allowable density or intensity of property throughout the jurisdiction, or it implements
Right.
a
So that's good for the
form-based
state.
code and does not
Yeah. Okay, go
substantially
ahead.
restrict the development of property throughout the jurisdiction, or it implements a form-based code and does not substantially restrict the development of property outside an urban service area.
Okay. So basically that's this. Oh, again, the state loves density, right? And this particular legislature, and I would suggest the governor's office, they're supportive of unlimited density. I mean, we've been seeing it year after year, session after session, that the Florida legislature is driving density with every tool in their toolbox. And this is why local governments, another reason, today in Florida, I would suggest that growth management is the number one outcry of involved Florida citizens. Florida citizens largely believe that Florida is being overdeveloped and it's being recklessly developed. So this is the state of Florida saying that you can change your comprehensive plan, land use plan, as long as the densities go up, but not down. And that works, of course, for property owners and for developers. It increases the value of their property, and all that. So it benefits the state of Florida. It benefits the landowner, the developer, and it ties the hands. Basically, what it's saying is you can't change your comprehensive plan to reduce densities and intensities, but you can change your comprehensive plan to raise density and intensity, Chuck. And you can just see that, where they're coming in on that, right?
Right. So also, HB 1465 deletes Florida Statute 252.422, Section 5, which requires the Office of Program Policy Analysis and Government Accountability to conduct studies on local government policies implemented after hurricanes, which are related to comprehensive plans, land development regulations, and procedures for review, approval, and issuance of site plans, permits, or development orders. So it deletes that, huh?
And that's just red tape, right? That's basically another one of those things. If you've got to go through some kind of a review period and you've got some bureaucratic agency taking a look at this, number one, you don't know what the bureaucratic agency is going to decide, and it takes longer. So no, we want to, again, it makes sense to me that after a storm, we want to fast track the rebuilding, right? We don't want our cities and towns to be all busted up and laying around for years and years with rubble all over the place. We want to get it cleaned up and fixed now. So they just deleted that whole regulatory process and got it out of the way.
Okay. Again, the legislation allows municipalities and counties to enforce comprehensive plan amendments and land use development regulation amendments, site plans, development permits, or development orders under the following circumstances. The applicant is the owner of the property subject of the application, and the owner is not a municipality or county. Do you want to address that or just go through them all?
Yeah, let's go. Let's just continue.
Okay. Um, the applicant is submitted by a municipality. The application, I'm sorry, is submitted by a municipality or county for the purpose of complying with Florida Statute 163.3191. The application submitted by the municipality of a county substantially increases the allowable density and intensity of property throughout the jurisdiction, implements a form-based code, and does not substantially restrict the development of property outside an urban service area.
Right. So basically, we've talked a lot about that already. Um, but again, this is basically the state of Florida encouraging form-based code is just basically what they have adopted as best practices for land development. It goes through all the stipulations about what your comprehensive plan should include and how you should determine, what uses go where and what the density should be and things like that. So, this is basically just getting back into the kind of standard procedures for creating these development plans, Chuck.
Yeah, so now we get into that area that you were talking about earlier on. If this change to the law allows landowners who are not business owners or residents to bring a civil action against the county or municipality for violating this section of the law.
Right. So now this is kind of interesting. So basically this is what I've said to you before. And this is really, I would imagine, what the major pushback is from local governments is that you're exposing us to liability. And keep in mind, Chuck, when the local government has to go to court, they're spending your money. It's expensive. These are millions of dollars in legal fees, oftentimes, right, to defend the local government against property owners and developers who are suing them. And that's your money. So you've got, as I would say that, oftentimes, particularly conservatives oppose, the heavy hand of government. And oftentimes we might find ourselves at odds with our city councils and with our county commissioners. On the other hand, they're spending our money. So when developers sue them, it costs us money. So we have to. It's really a sad situation that the state of Florida and the cities and counties don't collaborate better and work together on these land use initiatives instead of being adversarial about it, because this costs everybody a lot of money, ties up the courts. The amount of money required in order to maintain a judicial system that adjudicates this stuff is horrendous, just a huge amount of money. And the more we pit state government against local government and local government against developers and property owners, the more convoluted it gets. So, it's pretty nasty when you are sitting there as a county commissioner and you're trying to enforce the will of your constituents, and the state of Florida is telling you that if you step on these landowners' toes, and if you step on these developers' toes, we're giving those landowners and developers these civil tools to come after you and make your life miserable. So that's what you're facing, right? This is a standoff between state government and local government.
So finally, it does say that damages, attorney fees, and costs may not be awarded against counties or municipalities if the county or municipality allows the applicant's use of the property despite more restrictive changes to the comprehensive plan our land use development plan.
Which means they fold, right? You come in, you threaten a lawsuit, you have your lawyer threaten a lawsuit, and then the city and county takes a look at it and says, okay, I guess we'll let you do what you want to do. And in that case, they can't charge the cities and counties for their legal fees. That's what that says. So basically, if you do what you're told, it won't cost you any money. But if you don't, then you run the risk of exorbitant um, uh, legal, civil legal fees, Joe.
Okay, well, that concludes our overview of HB 1465. Would you like to give us one final comment and close us up?
So are you for it or against it, Chuck? Right? I mean, a lot of the stuff you're doing there, you could say that, of course, when the county or city comes against a landowner or a developer and they try to reduce the density of the property from entitlements that they already have, then the city and county shouldn't be able to do that. But you would hope that city and counties are fair and wouldn't do that. But the state of Florida is saying, no, cities and counties are not being fair. And therefore, we've got to put legislation on the books that prevents them from damaging, burdensome, keyword, and restricting the use of a property owner or developer's property, because locally we don't have confidence that these local governments are going to be fair, or they're going to honor their previous commitments in the way of land use, density, intensity. So we have to put we have to have statutory requirements that restrict them from reducing these densities, and we also have to have the stick, which is the statutory approval telling the courts that if the counties and cities levy an undue burden or restrict these developers, then there is financial retribution available to those developers against these cities and counties. And that just causes a lot of havoc at city council meetings and county commission meetings when constituents learn that they're being assessed for millions of dollars of legal fees over land use issues, Chuck. That would be my closing comment.
Well, thank you, Michael Levine, for an overview of HB 1465. And thank you all again for tuning in to our twice weekly live stream. Please follow us on Facebook at Restoring Our American Republic, or check us out on YouTube at Restoring Our American Republic ROAR. Please again, like and share our program. And remember, if you're unwilling to govern yourself, you will be governed by tyrants. Until next time, God bless you. God bless President Donald J. Trump. And God bless America.